That's how we lawyers got invented. So when a lawyer is fulminating there, turning red in the face, or is very clearly trying to throw a wrench or a spanner in the works, meaning to say he tries to object too many times so that the other lawyer already gets upset and angry. That is just part of trial technique.
Last 3 questions.
Good evening, ma'am.
Yes, my friend.
Kung yung pong vote sa TRO was very close, 13-12.
Right.
And then, ma'am, meron pa pong, ang sabi kanina, ma'am, sa Supreme Court, I mean 13-10. Meron pa pong magiging debate nito sa Supreme Court.
That's right.
May chance pa po ba yun na mabago yung decision na ito?
Ng Supreme Court or of the impeachment court?
Yes, ma'am.
No, because it's only for a temporary period. So there's no point for the senators to keep on debating it because eventually the temporary restraining order will expire on its own. And then we have to bring the debate now, not only within the impeachment court, but to the Supreme Court. And since we had a vote before on whether we would issue a subpoena or not, I was against issuing a subpoena, but I was outvoted. Now it will be the turn of the Supreme Court, of the impeachment court, to argue before the Supreme Court on why the temporary restraining order should be allowed to expire and should not be allowed to be made permanent. The hearing in the Supreme Court is to decide whether the TRO shall be continued indefinitely or whether it shall expire of old age, because it has a time limit.
Isa na rin po. Sabi po kanina ni Senate President Enrina sa Prosecution, they have no evidence and it seems that they are gathering evidence through the subpoenas being issued by the impeachment court. It's a fatal error on their part. Anong take niyo dito, ma'am?
In other words, the presiding judge is already losing his patience. He wants the prosecution to tell their story. What is your story? And they don't even know what is the narrative that they want to tell. They wait until the witness testifies, and this is their own witness. So in effect, it is an indication that they are not prepared. You can't do that. That's why the first day when I appeared, I said, you people should even have a trial brief. You should have submitted it to the court for approval. And I explained that the trial brief is simply an outline. Parang nangangapa sila kung anong sasabihin ng testigo nila. This is very unusual. In trial court, normally a lawyer, prosecutor or defense, will rehearse his witness before he is presented for many reasons. For example, the witness gets very nervous in front of the public, then he will get rattled if you ask certain questions. So normally the lawyer would already know what testimony he wants from the witness and will ask accordingly. But if you have a scattershot method, like you're just asking at random, that means you're not prepared. So of course the presiding judge, as I did when I was on the trial court for 5 years, will get impatient. You tell counsel, come to the point, counsel, or let's move on, counsel.
How would that affect the verdict?
Normally, the rule is the incompetence of counsel is a reflection on the client. The client is bound by his lawyer, even by the mistakes of his lawyer. So that will affect the decision if they continue in this pattern.
Last 2 questions.
Ma'am, sa tingin nyo hindi makukonvince ng prosec yung majority or 16 makukuha nila because of this statement by Senate President?
I cannot answer that question because that goes to the merits of the case, no? Like, who do you think will win? Are they doing the right thing or not? That goes to the merit of the case, and I'm not allowed to do that. But all I can say to you is to remind you that the voting requirements are not equal. To be able to convict, certain senators must gather 16 votes among themselves. So they have to try to attract 16 senators. Whereas to be able to acquit the people in favor of the Chief Justice or the defendant only have to gather 8. So this group for conviction are required by law to have 16 votes, whereas this group for acquittal are required by the same law to gather only 8 votes. So you can see the disparity. You can see therefore that it will be easier to acquit than to convict.
Good afternoon. I'm sorry to be late. I don't know if I didn't ask already. You had a long discussion between you and Representative Tubas about jurisprudence, and that you're saying that at least three jurisprudence that they cited do not apply, only the Intengan, which they did not adopt in their petition. Having said that, do you think that the Supreme Court later on will uphold the rights of the banks to protect the deposits and make the TRO permanent?
Well, that depends upon them. Certainly my opinion does not bind them, but it's a record, and I'm sure that they will decline to take any action after promulgation of the decision by the impeachment court. My position is that although the Supreme Court can exercise the power of judicial review, it does not possess the full panoply of judicial review as it would in an ordinary case, civil or criminal. With respect to the impeachment court, my proposition is that the court should only apply the most minimum judicial review, the lowest level of judicial review. So it is not correct to say, oh, once we allow the TRO to be obeyed, now at every turn the Supreme Court will TRO us. That will not happen because Supreme Court is also limited in its own powers, especially when it is, let's say, interfering with an impeachment court. So, in my view, although I was in favor of obeying the TRO today, in my view as a constitutional scholar, the Supreme Court has no power to overrule the final decision promulgated by the impeachment court. So that's not going to happen.
Thank you, Senator
You're
Santiago.
welcome.